We can't hear you.
Okay, can I be heard now?
I was talking about the main courtroom.
Can you hear me now?
Oh, shit.
David, we can't hear anything.
I am unmuted. Am I being heard?
Good afternoon.
Okay.
Are some that are a bit unfair in the way they were structured. Let me explain. When the specification of charges were created, they relied specifically on the statement or testimony of a client of Mr. Butler. The specification of charges dealt with legal matters, but there's never been a legal practitioner or expert that has participated in these proceedings to, for example, discuss the competency of the attorney. Most of the charges that have been levied against Mr. Butler involved a perception of one's legal ability. And when that is the topic of discussion, there necessarily has to be some legal expert involved to set the standard. That standard cannot be set by a client, especially one who feels that the outcome didn't come out the way they wanted it to. So from the beginning of these proceedings, we believe that there was a level of unfairness. It continued through the proceedings because once we reached the conclusion of the hearing, disciplinary counsel filed its proposed findings of fact and conclusions of law. And we get then to the committee report, which is all most of the mirror image of what had been submitted by disciplinary counsel. All of the evidence that had been submitted was ignored, at least all the evidence from the respondent had been ignored. Sure. In this particular instance, especially when you take the first 6 or 7 cases outside of the case that was in the Maryland District Court, those cases at least require, one, some understanding of the substantive law, meaning contract law and or foreclosure proceedings. It's our belief that if one understands those proceedings, then you reach a point where the interest and or the demands of the client are different than in ordinary cases. For example, many of the cases that involve the foreclosure proceedings were cases in which an individual needed more time to have an alternate disposition of real estate. It was not to prevail. The only way we believe that one prevails is if they pay the money that's owed either on an outstanding mortgage or in a foreclosure proceeding. And so to say that Mr. Butler's conduct had something to do with the outcome, we don't believe from a practitioner's point of view that that's an accurate assessment. I don't think that there was an admission that his conduct was not up to standard. I think Mr. Butler admitted what did or did not happen, but there was not this further consequence that was a cause of losing the house. No. And even if one looked at the record, without certain, the statement you made from Mr. Robinson, that would not be the case. Mr. Robinson had a mortgage. He did not pay the mortgage. And when he did not pay the mortgage, Mr. Butler goes into bankruptcy court to seek a stay. When that document, the petition was filed, there were requirements. You have to pay the the money that was owed before, and you have to pay the money that's currently being owed. Mr. Robinson didn't do that. So there's nothing Mr. Butler could do to save the property other than to, let's say, delay or request that he be allowed to catch up those pre-petition payments.
Isn't that something? Isn't that something that a competent lawyer could have and should have done in the instance of Robinson?
The answer to that is no, because Mr. Robinson said he did not have the money. He agreed when the petition for bankruptcy was filed, but after it was filed, we don't know what he did with the money that would have gone for pre-petition payments. So that's the reason that the house or the property was lost. It was not lost because of the failure to file a certain document. It's the same way with some of these. We don't believe that there was a principal argument. It was made, but then I don't know that that was the decision in lifting the stay. That argument was made in the paper submitted by the bank. Right. Well, I think you're accurate. That's what the hearing committee said. That was an argument that could have been made. The fact that an argument could be made has to have some consequence. If that argument had been made, there is no right for Mr. Robinson not to pay the mortgage. And that is no right for the court to, say that he's forgiven or that he's given some other chance.
I don't think the point that I was trying to make is I don't think the point that I was trying to make is that one argument is dispositive, because that means the other arguments that could be made. For example, there was discrepancy on when Mr. Robinson stopped making the payments. I think it was somewhere April to August 2017 when the bank made an incorrect assertion that it's like something like September, December. That he would take those payments back. Mr. Robinson did make it September, October, November, December, January 2018 payments. And it was only in February was payment was rejected by the bank, we then find out that he was in active foreclosure. So the fact that the bank had made an erroneous representation to the court in its motion to lift the stay, as to the accuracy of when this payment was made, wasn't that another argument that your client could have raised had he filed an opposition to the motion to lift the stay?
We don't believe so because most of the reason that pertained to Mr. Robinson was his pre-petition payments. He had none. The payments you're speaking of are post-petition. And on the post-petition, there was not this real give and take. It was strictly the pre-petition payments had not been made at all. And when he filed the petition for bankruptcy, he indicated that those pre-petition payments would be made. Now, it came up I think in Mr. Robson's testimony that he didn't quite understand his responsibility. We don't believe that that's a credible finding because both in the petition for bankruptcy, in the retainer agreement for Mr. Butler, and in the first meeting with the trustee, he was explained, and it is explained to a debtor that they need to make these payments. Mr. Robinson had not paid any. So the discrepancy. It's real. No, I'm not asking you to credit the testimony. I'm asking that you look at the retained agreement that was given to Mr. Robinson to evaluate whether or not that was a fair assessment of what I would consider uncontroverted facts. The fact that Mr. Robinson said he didn't understand something, I don't believe that that is a finding that the hearing committee should have been made in light of Mr. Butler's compliance with the rule of giving him a written retained agreement that explains at least twice what his responsibilities were. That's not all of it. Mr. Robinson had a degree in electrical engineering. Mr. Robinson had a degree in electrical engineering, and we believe it's preposterous that he wouldn't understand that he had responsibilities for those pre-petition payments. Because that's what, was decided. He paid nothing.
There also finds in the record that Mr. Robinson tried to repeatedly contact Mr. Butler prior to the lifting of the stay, prior to sort of losing his house to no avail. So any sort of ambiguity as to his understanding, because of the representation written, presumably wouldn't give up in the conversation with his lawyer that he hired for the purpose of saving his house.
Mr. Robinson, as I recall, testified when he had the discussion with Mr. Butler. This is before the early stages of the engagement. He didn't understand what Mr. Butler was saying to him. That's my recollection. But I think that the board would have to look carefully at the evidence, and the evidence here is that you have what we consider to be a disgruntled client who is saying, Mr. Butler caused me to lose my house. Well, that may be the case, but I think that that's the reason why I say you need to have legal practitioners who are part of the sausage making to be able to explain, especially to lay members on the hearing committee, what are the lawyer's requirements in this law. Mhm.
Because the lawyer in every case, disciplinary counsel would need to have an expert to testify as to what is popular level of practice. That's one part of the question. Another part is that there are some things, my understanding of the record, there are some things that Mr. Butler that will be failure to respond orders, failure to hear, failure to respond orders to the cause. It's still a real argument for the community, and for the local.
Well, the way I look at, how these cases are put together, there is an allegation that there was a violation, and then immediately was the client harmed, whether or not that's a part of a finding or not. And so here I'm saying, if you have, let me give you an example. Something that happened years ago. When President Bill Clinton was served with a complaint, by all accounts, one says, have your lawyer to answer the complaint. Well, it would have behooved him to accept the default. And that would have been certainly against the rules. You get the complaint, you file it within a certain amount of time. But for his particular circumstance, it would have been better if he had not filed an answer.
Say, Bill, I think you just take a default.
That's correct.
Just fail to-
Well, that's true. But the reason that I mentioned that is this. As you just mentioned, a lawyer would have to be involved in that. So what we're saying is Mr. Butler's conduct should be measured by a practitioner in the field of bankruptcy and contract law to make certain determinations. We don't say that all of them comes out in his favor or not. We're saying that when you begin to talk about the competence of a lawyer, and especially in this circumstance where we're dealing with, either contract law or bankruptcy law, we think that an expert was required to participate.
I think Ms. Sargent's point we're pursuing. It appears to me that you're arguing that certain inactions or failures to what the hearing committee perceived and found to be certain failures to act by your client were actually strategic decisions by him in connection with certain of the matters. Is that fair to say?
The cases are a little different. They are,
But you are saying that some of the failures to respond or failures to follow up or file a motion, they were, seems to me you're saying they were strategic decisions.
I am not saying that. I'm saying that if there had been a practitioner in either foreclosure litigation or bankruptcy, the steps that Mr. Butler took, whether
Or did not take.
or did not take, well, let's say that may have not taken on the sort of front end, but there were other activities that would have sort of come full circle and made things correct. It may not, let me give you an example.
That your client's conduct, and you're saying that things happened and your client's conduct was irrelevant to whether or not they were effective. And to this starting point, this might be this, if these were strategic decisions by Mr. Butler, which I guess you're saying,
Right.
if they were, and if you were trying to see them to that, it would kind of argue against that we decisions, given that Mr. Butler appears not to have consulted with the client and informed them about what he was doing or not doing, and why he was doing it or not doing it. So that failure to inform the client, who the client informed was arbitrary, seems to me significant to what you're arguing about. Whether and how you find whether it's common.
Well, I have not, agreed with your statement about, whether or not it was strategic. I'm saying though that when a lawyer is engaged in a specific area of law and one that's generally not practiced by, most lawyers, that I believe that the respondent lawyer is entitled to have the standard set by a legal expert.
not appear to, or whether or not it's kind of short, or whether or not it's taking the consequences, yeah. It seems to me that's not a practice serious issue. And hope you understand why would you think that incompetent, you need an expert to explain, or in this area of practice, you have to update your content manual, and you don't have to show up before, that's where I'm getting stuff.
Well, that is, what we call the Maryland case. I'm not saying that an expert is needed for the Maryland case, but I am saying if you take a look at the Langwell Jones case, where there was criticism of Mr. Butler for not filing in opposition to a motion for summary judgment. And the discussion about whether or not Langwell Jones was actually the person who had come to court on a prior occasion and filed a pro se motion. In that instance, the question, that I would think a legal practitioner would answer is, was there a defense that could have been asserted in an opposition to a motion for summary judgment that would have freed Mr. Jones from whatever penalty he was facing?
Counsel, just a question. Did you ever win a case that you thought you were going to lose?
Mr. Butler's failure to respond to this motion didn't have an effect on the case because there would be no violent defense and no prejudice to the client. Is that basically what it is?
Well, that's similar to it. And if
Prejudice or a lack of prejudice. The prejudice is really the standard that we're supposed to look at.
no, I'm not saying, I understand, but I'm not saying that that's a prejudicial argument only. If you file a piece of paper in court and you sign your name to it, then you're saying that what I'm filing is a legitimate defense. And it,
The initial petition for bankruptcy, these states petition for bankruptcy. You're filing that initial petition for bankruptcy. You was at least what was position that he was filing petition for bankruptcy, didn't expect that he was going to file a motion for legal stay or a motion for summary judgment. Because why would you then be able to file the initial petition for bankruptcy, but yet you can't pose a dispositive motion for lack of a defense?
well,
Doesn't that mean that the initial pleading that institute the entire matter?
no, I think we're getting the two types of cases. The one with the bankruptcy, excuse me, is one that's commenced by the filing of the petition for bankruptcy. In the foreclosure, it's, a complaint filed against an individual because they didn't pay their mortgage. And so in that instance, in the Langwell Jones case, a motion for summary judgment was filed by the creditor. And there was no response. And if you drill down a little further in that case, there did not exist a building on the property that was supposed to be secured. And the debtor wasn't concerned because he couldn't pay the money on the outstanding mortgage. And there was never any testimony that he could. No objection. Let me make sure I'm understanding. They cannot hear what's going on now?
We can hear Johnny Howard.
Right, I don't have any objection, but if it's a reboot that's needed, can we interrupt and get them rebooted? Okay, all right. Mm.
Did you mind have the opportunity to present
My client doesn't bear the burden, and that was not, a part of, what we would normally would do. Um, that's sort of not a question, I think, that we would have been able to react to. Prior to the hearing committee, prior to the convening of the hearing, there are deadlines for submitting, information, one of which is the identity of any expert witness. And at that stage, there was no overture from respondents' part to introduce an expert witness. There had been an indication of the respondent's position made in the motion to sever the charges, that an expert is a likely person that disciplinary counsel would have to have to present in order to sustain the charges. But the respondent did not introduce an expert prior to the hearing.
Okay.
Thank you.
Good afternoon, and may it please the board. Jack Metzler for the Office of Disciplinary Counsel. I'd like to step back for a moment and just talk about the findings that the hearing committee made in this case. If you look at the hearing committee's report, they encompass about 40 pages. There are 120 numbered paragraphs. And in great detail, the hearing committee finds what happened in all of these cases. And if you go through them, what emerges is that Mr. Butler engaged in a prolonged and egregious pattern of neglect and incompetence in multiple cases for 7 clients, of course, over 8 cases. And the pattern is clear in case after case. Mr. Butler fails to respond to dispositive motions or effectively dispositive motions in the case of a motion to lift an automatic stay. He makes his own filings that are deficient, and the courts or the clerks notice that they're deficient and give him multiple opportunities to correct them, which he does not do. The courts then order him to appear, to respond, and he doesn't do it. He doesn't do it again. And as a result, his clients lost their cases. Mr. Robinson lost his home. Mr. Jones had summary judgment granted against him, and the others all, and Mr. Clayton, whose case never got off the ground. And at the same time, the courts spent inordinate amounts of time trying to track down Mr. Butler, trying to get him to respond, which he continually failed to do. So those facts establish the violations that we're talking about.
Good question. And I keep it in my head, she was involved in pregnancy administrative justice.
Yes.
And you lay out now things that clerk's office had to do before that period. Can you, 2 things. First, which conduct will be which count? So that you have, all of the counts, administrative justice violation. And really 8 and 4 years of that. What happened in those situations that police things rises to the level of
Sure. Serious interference with the administration of justice. So what the courts have, or the court standard is that to be a violation of Rule 8.4 D, the conduct has to be improper. It has to affect a specific case or a specific case or tribunal, and it has to be more than a de minimis effect. And the commentary to Rule 8.4 says something like not showing up for a hearing is a violation of 8.4 D. So the cases in which, well, that's what the commentary says. I think it's comment 1 or maybe comment 2. Don't hold me to that. So the specific counts in which there was a finding that the hearing committee recommended finding a violation of 8.4 are the Jones matter. And in that case, I think it's based on Mr. Butler's failure to appear for a hearing when he was ordered to appear after summary judgment default was granted by default against his client. His client then moved to lift that and said, my attorney never told me about this. And so the court said, well, let's bring him in and find out what happened. And Mr. Butler did not show up to that hearing. I think that is the main basis in that count for the 8.4 D. In the bankruptcy of Mr. Garamu, again, there was a failure to respond to, so that Mr. Garamu had two cases. First bankruptcy petition was the subject of a motion to dismiss that Mr. Butler never responded to. And then in the second one, Mr. Butler filed a motion to extend the sort of tardy motion to extend the automatic stay. And there was a hearing held on his own motion. Mr. Butler did not show up. So I believe the basis for the 8.4 in that one is the failure to show up, but also the failure to respond to, I believe there were some orders in the initial bankruptcy petition. The third one is the Fitzgerald matter, and I believe in that one there were also orders to respond, in order to show cause. And then in addition, a failure to show up at a hearing. And then the easiest one is the Clayton matter, where over 10 months, the court repeatedly, time and time again, was asking Mr. Butler to essentially serve the defendants in the lawsuit that he filed, gave him multiple extensions. I believe Mr. Butler failed to show for 4 hearings. After being directly ordered to show up by the court wound up having to call him on his cell phone on the record and threaten him with contempt in order to get him to respond. So stepping back again just a bit, the failures to each of these are a violation of 8.4 because they affected the judicial process in more than a de minimis way. When Mr. Butler doesn't show up for his own hearing, he is depriving the court of what the assistance of counsel in deciding the motion. And when he fails to show and requires the court to chase after him and call him on the phone, that's taking up the court's time. That is taking time away from other cases that are that the court should be devoting its attention to.
Response about this particular the Jones matter. How obvious was it that any sort of competent attorney would file an opposition to the mortgage company's motion for summary judgment? Like, how obvious should we find that back that somebody would have filed an opposition to that case?
So I think the tenor of Mr. Butler's response is to that is essentially that Jones was going to lose anyway, and as the board has said during the argument, that's the kind of decision that you make in consultation with your client. Mr. Jones clearly did not want to give up. When he found out about the summary judgment, he went on his own and tried to get it and did get it lifted and filed his own opposition. So just from at the base level, you don't need an expert. Has nothing to do with the intricacies of bankruptcy law to know that you don't lose a case without even telling your client about it, without consulting. Now, it's one thing if he thought it was, if he truly thought that that this case was unwinnable, that there was no argument to be made, then he needs to go talk to his client about that and say, look, we're going to have to concede here. Maybe we can do something else. But that's not what happened. And in fact, to the extent. Well, as often happens, the conduct, could come under many under several different rules, but certainly communicating with your client about the potentially losing the entire case is something that a competent attorney would do. It is it is a skill and care with which attorneys will ordinarily provide to other clients. And I just want to touch on the idea that that maybe it was okay for him not to respond because they were going to lose anyway. Going back to the administration of justice count, the rule 8.4, if it's true, if it were true, and I don't think it is, but if Mr. Butler truly had just decided, I'm going to ignore these things, these orders from the courts and so forth, because there's a strategic advantage, it'll give us some more time or something like that, even if he didn't communicate to his client, that just exacerbates the rule 8.4 violation. It's essentially saying, I'm going to, on purpose, waste the court's time, ignore these calls, ignore these orders, and so forth.
So, give that a clearly, I'm a little bit of respect to, have a little bit of respect for us. So, how to involve multiple funds, right? With an 8.4 violation goes to the aggregate of this kind of conduct, or is ODC saying that each one of the ones that we just listed would they have been sufficient on the level to be able to afford the file? Is it the cumulative effect, or is it each individual act, or are you saying it's both?
No, I think what we would say is in each of these cases, he violated rule 8.4. So with the 4 that I meant, well, the 3 are 8.4, and then the Clayton case is, of course, the Maryland 19-308.4. So in each case, and I think the hearing committee's opinion bears this out. They found that they find he violated rule 8.4 in the Jones matter because of X, in the Becton matter, not Becton, in Jeramu, for X reasons and so forth.
We didn't get to this, or briefs response to the issue with respect to this sort of general umbrella testimony that Judge Fields sort of opining about what would have happened if we had filed an opposition in that case constituted the advisory opinion, that advisory opinions certainly not proper cases. So I respond to specifically about the case, judge not being certainly sort of advisory opinion decide cases, and that the trustees communication with Mr. Robinson that had Mr. Butler file his opposition to this house would be saved. But those are sort of not only hearsay, but sort of backbone of including improper testimony.
So just so I understand the question, this would go to specifically, and I just want to back up for one moment and note that of all the violations that we've talked about, and I think it winds up to be almost 30, if we count per rule per case. There is just one rule that, in which we compared the lawyer's conduct to what another lawyer would have been. And those are that's rule 1.1B, which specifically says affording the clients with the skill and care that attorneys would ordinarily give people in other cases. So the scope of the expert argument is right. I just want to be clear as to what we're talking about. And so as far as whether an expert opinion came in on the standard of care, the vast majority of the violations do not have anything to do, as Member Cassidy mentioned, with bankruptcy law. They are responding to a motion, responding to a court order, showing up to court when the court orders you to do that. You don't have to be a bankruptcy petitioner. You don't even have to be a lawyer to know that you follow orders. When courts order you to do things, you do it. And certainly as a lawyer, you don't need to be a bankruptcy expert to know that if a dispositive motion is filed, you need to respond to it in some way. The only, I think, as I read the hearing committee's report, the only real issue of bankruptcy law in these cases is whether is the importance of the automatic stay that comes in on bankruptcy. This is what was the subject of the motion to lift in Mr. Robinson's case, and then in several other cases when Mr. Butler had filed basically a defective in various ways motion to extend the automatic stay. And the testimony about that exists. It's in the record. It doesn't come from Judge Teal. It comes from respondent, and you'll find it in the hearing committee's report. He's the one who explained how important it is to have this automatic stay, and how it prevents a court from or prevents a creditor from foreclosing on a mortgage. So as far as the standard of care being established improperly, I just don't see it. But I should also say, the violations here largely have nothing to do with bankruptcy, except for this one fact, which is undisputed, about the importance of the stay, the automatic stay, and keeping that in place. But beyond that, Mr. Butler has not explained how, or my friend has not explained how Judge Teal or the bankruptcy trustee or what they said affected the decision. And I'll take it back once again to the findings, the detailed findings made by the hearing committee.
That's not my question. And I don't want to go too far afield and ask for an advisory opinion from you, but.
No, I'm happy to do that.
Under what circumstances would disciplinary counsel's office provide expert testimony? I mean, it's not required with the charges here. Can you summarize for us briefly the circumstances of the kinds of charges that would require expert testimony or could require?
Well, the one example is one actually cited in the, well, I guess the main times when we would call an expert have to do when an area of law, and I'm going to be thinking right now of an example while I'm talking, so forgive me if I don't get to it, is when there's an area of law that would not be otherwise clear to sort of an ordinary practitioner. Our hearing committees are made up of 2 lawyers and 1 lay member, so that it's not a complete absence of sort of any legal knowledge on behalf of the decision maker. That would be the standard. But so, for example, an area of securities law, or patent or trademark. These are areas which could well involve sort of expert analysis that would tell you what an ordinary practitioner would do. Did this patent application, should it have refuted the prior art, for example? Or would a competent patent examiner have, or patent attorney have found this piece of prior art, which wound up making the client lose their case, for example? It's those sorts of areas where the practitioner can add, where an expert can add value, and it's not obvious what a competent practitioner would have done. Now, that's unlike here, where, like I say, when a court orders you to show up, an expert doesn't need to come in and say, most lawyers would show up. You don't even need a lawyer for that, as I said. So, but just getting back to the scope of the expert argument in response to Mr. Horace's question, or not the scope, but the effect. What I didn't hear from Mr. Howard, and I didn't see in the brief, is how any of this matters, how any of this means that that any of the violations wouldn't have been a violation if only an expert had come in. And if it's true that an ordinary practitioner would just ignore things, well, I think that it was beholden on the respondent to establish that, because ordinary practitioner or non-practitioner is going to think that they should.
To ask you, in terms of the proposed sanction here, what criteria should the board consider when deciding whether the state suspension is condition to the appropriate?
So the board's not bound by the hearing committee's recommendation. Just to be completely forthright, we did not take an exception here, because we would not contest that the recommendation is within the range of acceptable sanctions based on past cases. That said, we asked for a year with fitness. Now, it seems to me that what the hearing committee thought is they sort of imposed their own sort of mini version of fitness, where they said, look, if he will go in and meet with the practice management people, agree to let them confer, to adopt their recommendations, agree to let them come in and confirm that he's adopted them, and not have any further disciplinary violations, we're satisfied that he can continue to practice and do so competently. But if he can't, they think, then that would tip the scale, and they think he would at that point need to show that his fitness. Now, that said, I think it is worth considering, or it is worth mentioning, that the elements in whether to impose fitness include an attorney's conduct since the misconduct occurred, whether they take responsibility, and whether they've making any efforts to remedy past harms. Those facts were unknown to the hearing committee when they made this recommendation. But now we know where Mr. Butler stands on that. He thinks he's done nothing wrong. He thinks all of this conduct was perfectly fine. It doesn't merit any sanction at all. He's not taken any responsibility. And so, if the board doesn't have confidence that the confidence that the hearing committee had that Mr. Butler would be able to fulfill these conditions and be competent afterwards, and there's well, I think you certainly are not bound by the hearing committee's recommendation, even if it is within the range. Well, the record includes, I think, his own filing, so I don't see any reason why you wouldn't be able to consider that.
Before we met with the phone, said, and check with, members that are just being enrolled. Tyler, do you have any questions?
Mr. Tiger, do you have any questions? Can you guys hear us in the courtroom?
Thank you. Yes, no, well, yes, I do. One, is there a case that holds clearly that there is a distinction between the duty to consult, communicate, and so on, and the question of outcome effect? Is there a kind of harmless error rule that that is in operation here, or as you suggest,
I don't think they can hear us. Mr. Tiger, do you want to send your question in the
Oh,
chat and
sure.
I'll forward it on?
I'll send it. Thank you. I'll do it right now. J. Willikers, more. Chat.
He's going to send me the question in the chat and I'm going to send it to Bernadette.
Can you have him call my number?
Well, here, let me see if I can just put him on my speaker. Here.
Okay, that's fine.
Mr. Tiger,
Yes. Mhm.
David, can you hear him?
Yeah.
David, can you hear Tiger?
Yeah, I
Okay.
can hear that.
You can ask your question, Mr. Tiger.
Okay. Oh, I can hear. Can you hear me now?
I have them on through my phone.
Okay, great. Mr. Metzler, is there a case that clearly gives us some direction as to what, if any, effect the merit or lack of merit of the underlying claim has to do with the lawyer's duties of diligence, communication, and so on? Is there a good, you got a good case on that?
Do I have a good case? So if I understand the question, it is whether, can we do? I'm not going to be able to go and, okay. So if I understand the question, it is what is the relationship between an attorney's responsibilities to under the rules as compared to the merits of the underlying case, and my answer is
Yes.
Those two are independent. Clients with losing cases deserve competent attorneys, and I think, you know, to the extent that these clients you know, had difficult cases, we will never know what defenses they might have had or could have had, because the person who was in the best place to make those defenses didn't do it. You know, I have read the motion to dismiss in Mr. Jones's case, and it looks pretty good to me, but I've filed a lot of motions I thought were pretty good. And what happens on the other side is they file something that sounds pretty good, and then a judge has to decide. Here, Mr. Butler didn't file anything, and his you know, and if it were if it were true that these cases were so unmeritorious that they shouldn't have been brought in the first place, well then, you know, it was again upon Mr. Butler, who took these engagements on, and I believe what the cases say about the Rule 1.1 is, you know, it's a failure to fulfill your responsibilities as the responsibilities of the engagement and to your client. Your responsibility is to represent your client, to show up for them, to, you know, make the argument that you can make. And you know, I don't want to know what the arguments should have been, but they certainly shouldn't have been just, you know, not responded to at all.
Thank you. Good.
All right, so thank you very much.
Thank you.
That's good. Good. See, he's got it.
When one considers whether or not the attorney lived up to the either demands of the client or the expectations, there's more to consider in this particular case than whether or not a hearing was missed. For example, there were loss mitigation efforts that were conducted in the foreclosure cases, which is ordinarily standard. Usually when a case is brought into foreclosure court, it's brought by a creditor. So the debtor doesn't have anything to do with the actual bringing of the case. The debtor can seek relief in a number of ways, some of which are in the court and some of which are sort of tangential to the court, like mitigation efforts. But one of the things that's really missing from most of the cases that were brought against Mr. Butler is that the actual client has never made an appearance or a statement about what they desired in a proceeding. In these cases where a person owes money, the real defense to that is pay up. If you have the money, pay up the money. If you don't, then you have to go to sort of alternative plans, one of which was loss mitigation efforts. That was what Mr. Butler testified that he did for these clients. There's not been any evidence to refute it. And so to say that, the fact that, these clients were embroiled in some litigation, it wasn't because Mr. Butler filed a complaint.
Well, I'd like to put a question about that, if I may. I've been practicing law in this town a long time, and
I don't think they can hear you. I think
They
they're gonna
can?
ask you, I
The
think they're gonna
only
ask you
case
towards the
where,
end.
in my recollection of the record, was in the Maryland case regarding the appearances. But in terms of the Langwell Jones, there was one instance where the court, requested Mr. Butler's presence. And then when Mr. Butler did come to court, he inquired, well, who was the person that appeared? And from Mr. Butler's understanding, based on the physical description by the clerk in the courtroom, it was not Langwell Jones who appeared. It was an interested investor.
okay. If I ask a question, can I be heard now? Can you hear me?
That's
Yes?
They can't hear you right now. I
Okay.
think Bernadette will ask you at the end if you have any questions.
Okay.
I think you're sort of misunderstanding the exchange. There was a person who came to the courtroom. And Mr. Butler understood that that person, this is before Mr. Butler was there, he understood that it would not have been Mr. Jones. And when the court said it was Mr. No. If you recall in that record, there was difficulty reaching Mr. Jones. And that's why Mr. Butler was surprised when the court said Mr. Jones came to the court. Not, excuse me. We don't believe that that was Mr. Jones. That was another person that Mr. Butler identified as Mr. Abdullah. And Mr. Abdullah filed the filings.
Whoever filed the pro se motion. Signed.
We believe that the filing does speak for itself, but that was not Mr. Jones who made the filing. It was this. It was in the description that was given by the courtroom clerk as to how this person looked who came to Mr. Jones's case. Well, that was the same, it was the same person. The person that was described.
January 12th, 2018.
Right.
That is the hearing at which someone allegedly other than appeared. Before 20, if her client had appeared, that he would have known what he did not appear.
Well, he did not appear at that hearing, but that doesn't lead to the conclusion that the person who did file the motion.
I submit that for the purposes of clear. I would say I'm sure that the relevant question is whether your client appears to be here, if not client. And it appears that he didn't.
Well, there were instances offered where the notice of the hearing did not reach Mr. Butler, or there was some confusion in that process. But I would say to you, one of the critical aspects is, did the client want to do anything in opposition to the motion for summary judgment? And when I say well, Mr. Butler appeared at many of the hearings, and if he didn't, there was some difficulty in the transmission of court dates, either from the court or at one point in time on some of the cases was because of his email system having been hacked. Well, excuse me, the case we were talking about, the Langwood Jones, that was not a bankruptcy case. That was a, case in the Superior Court on the docket. But even the cases that were in bankruptcy court, I think it was important to understand the objective of the client. Most of the clients in bankruptcy court have not been able to pay. They are looking to buy some time to make some alternate arrangement. Could be a sale of real estate. They need a window of opportunity. And that's what happened in these cases. It's not as if an individual who had a legitimate right to complain about an automatic stay lost the ability to assert a defense. That was not the case. And even when you get to Mr. Robinson's case, an automatic stay is not something that you just breathe out. When you file the petition for bankruptcy, you make an agreement. I will do this, and because I promised that I will do this, then the court says, we'll give you an automatic stay.
Smart enough to put the question in the chat.
Okay, great, thank you.
And the question is, I think the lawyer make the legal style decision in cases.
Well, that's sort of, twofold. Sometimes it depends on what kind of case it is. But oftentimes the lawyer gives guidance on what a strategy can be. And then, at other times, sometimes the client can direct it. It depends on, what the issue is. It wasn't a payment to the lawyer that I was speaking of. It was a payment to a creditor. Right. Mhm. Okay, and I'd like to, make another couple of points. Especially about the types of cases where expert witnesses have been presented by disciplinary counsel. One of the cases that was heavily relied on this case was N. Ray Lyles. And in that case, it involved a issue of bankruptcy law. And there was an expert that testified in that case. And even in the Lyles case with the expert having testified, and we think on facts that were more egregious than those that are being asserted here, there was not the kind of penalty that the hearing committee is seeking to impose on a person who's never had a disciplinary violation. And so we think that disciplinary counsel is kind of waffling on when they do and when they don't. But certainly, in my experience in this area, I've not seen cases brought where you don't even bring the clients in or, parties who agree. We don't know what the objectives were of these clients. And it,
Trust the plan counsel's, remorse.
that's an interesting, observation. A lawyer who's challenged or, whose license is being challenged has a right to put on a defense. And so I've always tried to find out where is it or when is it that the lawyer says, I understand and I just say that. Does a lawyer have to bow out from presenting an argument to advance the position? And so there's been no evidence that Mr. Butler has either not appreciated the seriousness of these proceedings or not, done what he's been required to do. So
Most of your arguments have been sort of based on the Robinson cases in general. With respect to the case, the person that you have, it seems to be maybe more critical that a failure to effectuate proper service, failure to obtain summons from the clerk, which results ultimately after multiple opportunities, including the credit it's on the marshal doctrine in the hearing, if the case gets dismissed, the case that was filed in the last day of the certification. Is there any sort of acknowledgement on this?
well, I think that if you look at, the briefing, we have not posited any theories regarding that particular case, other than the fact that there was non-public discipline involved in that matter. That's about all that I think that has been said in the papers regarding that particular case.
That it wasn't made public?
It was not, yes, it was not
What
published.
about that?
Thank you.
Sorry, counsel, please, this question is actually covered by Mr. Floyd. So, definitely we can- on that. Because we're not-
Well, I certainly don't think that one should, sort of conclude that Mr. Butler doesn't either recognize the seriousness of it or what his conduct was. But I'm not so certain where the forum is for one to communicate that. If they've asserted, well, let me just back up a little bit. We were talking about motions and responses to motions. And a response to a motion, let's say, by the board's conclusion is one was necessary. The same in these proceedings. The issue is, what is the content of, the opposition or the response? And these arguments that have been presented, we believe are arguments that are available to Mr. Butler. He has not been asked to reveal what his personal feelings are. And I don't think that one should be asked because it's a compromise of whatever position they're advancing. But certainly Mr. Butler takes this seriously. This is not something that he does not understand the seriousness of, and he doesn't, wish to be criticized because he hadn't just come in and say, oh, I give up. And I think that, a lawyer deserves the ability to challenge an action that is a challenge to his or her license. It has nothing to do with whether or not they don't understand and appreciate it, but I don't think that you have to come in to say, oh, disciplinary counsel, I'm on my knees and, blah, blah, and blah, blah. That's not the circumstance, but he is not an arrogant individual. He is not somebody who's uncaring. And if there was a couple of lines in the transcript where he indicated, how it was he, attempted to treat his clients. So we don't wish any prejudice by the fact that, arguments are being made on his behalf.